Get ready for the dictation in 3, 2, 1, start. In Sunil Batra versus Delhi Administration 1978 4 SCC 494, the Supreme Court again speaking through the legendary Honorable Justice V.R. Krishna Iyer gave whole new dimension to the prison reforms jurisprudence in this country by observing that all action against and treatment of the prisoner must be commensurate with his sentence and satisfy the test of Articles 14, 19, and 21 of the Constitution of India. Stop. The Supreme Court in that case laid down detailed guidelines for securing basic human rights of the prisoners. Stop. In that case, their lordships observed that it is imperative as implicit in Article 21 of the Constitution that life and liberty of a prisoner shall not be kept in suspended animation or congealed into animal existence without the freshening flow of fair procedure. Stop. Fair procedure in dealing with the prisoners calls for another dimension of access to law provision within easy reach of the law, which limits liberty to persons who are prevented from moving out of prison gates. Stop. No prisoner can be personally subjected to deprivations not necessitated by the fact of incarceration and the sentence of court. Stop. All other freedoms belong to him to read and write, to exercise and recreation, to meditation and chart, to creative comforts like protection from extreme cold and heat, to freedom from indignities like compulsory nudity, forced sodomy, and other unbearable vulgarity, to movement within the prison campus, subject to requirements of discipline and security, to the minimal joys of self expression, to acquire skills and techniques and all other fundamental rights tailored to the limitations of imprisonment. Stop. Their lordships in that case further observed that district magistrates and sessions judges shall personally or through surrogates visit prisons in their jurisdictions and afford effective opportunities for ventilating legal grievances and shall make expeditious enquiries thereinto and take suitable remedial action. Stop. The state shall take steps to keep up to the standard minimum rules for treatment of prisoners recommended by the United Nations, especially those relating to work and wages, treatment with dignity, community contact and rights, human dignity, and human sympathy. The Supreme Court in Amar versus Superintendent Central Jail, Tihar, New Delhi, AIR 1978 SC 1514, held that imprisonment does not spell farewell to fundamental rights, although by a realistic reappraisal courts will refuse to recognize the full panoply of Part 3 enjoyed by a free citizen. Stop. Article 21 read with Article 19 1D and 5 of the Constitution of India is capable of wider application than the imperial mischief which gave it birth and must draw its meaning from the evolving standards of decency, and dignity that mark the progress of a mature society. Stop. There must be some correlation between deprivation of freedom and the legitimate functions of a correlational system. Stop. It is now well settled that deterrence, both specific and general, rehabilitation, and institutional security, are vital considerations. Stop. Para. Moreover, the rights enjoyed by prisoners under Article 14, 19, and 21 of the Constitution of India, through limited though limited, are not static and will rise to human heights when challenging situations arise. Stop. In a recently delivered judgment in the case of Shabnam versus Union of India and others, 2015, 6 SCC 702. The Supreme Court observed that even after conviction, when a person is spending prison life, allowing humane conditions in jail is part of human dignity. Stop. Prisons reforms or jail reforms measures to make convicts a reformed person so that they are able to lead normal life and assimilate in the society after serving the jail term are motivated by human dignity jurisprudence. Stop para. As has been noted above, state government, when this matter was taken up by the court on different dates, has been assuring that all positive steps to improve the conditions of prisoners in various jails of the state and cited number of orders, work orders to claim improvement in the prevalent conditions, but we are at pains to note that except on the aspect of wages of skilled prisoners working in Udyog who were paid at the rate of rupees 40 has been increased to rupees 150, and unskilled prisoners who were paid at the rate of 20 per day are being paid rupees 130 per day, by completely omitting the category of semi-skilled persons who were being paid at the rate of rupees 30 per day earlier, and appointment of non-official visitors. No satisfactory progress has been taken place despite repeated persuasion, imploration. Stop. Thank you.